Welcome to the deep dive. Today we're heading straight to the legislative heart of India. We've got this stack of sources here, really detailed stuff, diving deep into the Parliament of India.
Yeah, we're looking at its structure, how it actually functions, who's in it.
And maybe most importantly, what it does, its powers, how it gets things done.
Exactly. Our material, it really draws from a specific chunk of the Constitution, Articles 79 to 122 in Part V. And it's backed up by related laws, parliamentary practices, stuff that's built up over time.
So it covers the whole gamut, organization, procedures.
Everything. The core principles, the day-to-day workings, the roles of the officers like the Speaker, the Chairman, even the special rights, the privileges members have, and of course the big one, the powers of Parliament.
Right. So our mission for this deep dive is to really, unpack all of this. We want to get beyond just the headlines, look under the hood at the engine room of Indian governance.
Find those key insights, the really important nuggets of knowledge.
Yeah, give you a solid shortcut to understanding the core mechanics of Indian democracy.
And it is absolutely central.
Yeah.
Parliament is the main legislative body of the union government. It holds this preeminent position in India's whole democratic setup.
And that centrality comes from?
It's a direct result of India choosing the parliamentary form of government, what's often called the Westminster model, borrowing quite a bit from the British system.
Okay, let's start right there with that fundamental structure. Our source lays it out pretty clearly. Parliament isn't just one thing, it's three parts together.
That's right, three integrated parts. The President, the Council of States, and the House of the People.
Those names we hear more often, Rajya Sabha and Lok Sabha, when did they come in?
Those were adopted officially back in 1954. So Rajya Sabha is the Council of States, that's the upper house, sometimes called the second chamber or, the House of Elders.
And its main job?
Fundamentally different from the Lok Sabha. It represents the states and the union territories specifically.
Okay, and the Lok Sabha House of the People, that's the lower house, the first chamber, the popular house.
And it directly represents the people of India as a whole.
So this structure, president plus the two houses, the source calls it president and parliament.
Yeah, and that directly mirrors the crown and parliament idea in Britain. It really highlights a core principle of the parliamentary system. This close link, this interdependence between the legislative side and the executive side.
Unlike, say, the U.S.
Exactly. In the U.S., the president is separate from Congress. Congress is just the Senate and the House of Representatives. The president isn't constitutionally part of the legislature itself. That reflects their separation of powers doctrine.
That's a really key distinction. It shows how India sort of blended different traditions. Okay, let's dive into the houses themselves. Rajya Sabha first. How do members get there?
Well, for the states, the representatives are elected by the elected members of the state legislative assemblies. So it's not a direct public vote.
And they use that system, proportional representation.
By means of the single transferable vote.
Yeah.
Yeah. It sounds a bit technical, maybe?
Break it down for us. What's the main takeaway?
Well, at its core, it means seats are allocated roughly in proportion to the votes different parties or groups get in the state assembly election. And the single transferable vote mechanism, it lets voters rank candidates, and their vote can move if their top choice doesn't need it or gets knocked out.
So basically, the political makeup of the state assembly gets reflected in its Rajya Sabha members.
Pretty much, yes. That's the idea.
And how many seats does each state get? Is it equal?
No.
Yeah.
And this is where it gets really interesting, especially when you compare it to other federal systems. In the Rajya Sabha, seats are given to states based on their population.
Population, not just statehood.
Correct. So a big state like Uttar Pradesh, it gets a lot of representatives, 31, according to the source's examples. But smaller states, like Tripura, they only get one.
Wow, that's totally different from the U.S. Senate. Every single state, big or small, gets exactly 2 senators, equal representation for the states as entities.
Precisely. India took a different approach for its Council of States. It represents the states, yes, but the weight of that representation is tied to the number of people living in those states. It's a key feature.
What about the union territories? Do they get seats?
They do. They're represented too, though their members are indirectly elected by a special electoral college set up for that purpose. Right now, the source says only Delhi, Puducherry, and Jammu and Kashmir have enough people to get representatives allocated.
And then there are the nominated members, 12 of them.
Yes, the president nominates 12 members to the Rajya Sabha.
Why do that? What's the purpose?
It's really about bringing in expertise. People with significant knowledge or practical experience in fields like literature, science, art, social service. people whose insights could be really valuable in debates, but who might not be cut out for or even interested in running in an election.
So it enriches the debate beyond just politicians.
That's the aim, injecting diverse, sometimes non-political expertise into the legislative process.
Okay, let's switch gears then. Lok Sabha, the House of the People. Our source says 543 elected members currently.
Right. 524 from the states, 19 from the Union territories. And the key principle here is direct election. Members representing the states are chosen straight by the people from different territorial constituencies.
Based on universal adult franchise. Everyone gets a vote.
Everyone over 18? Yes. And that age itself is a point worth noting. It wasn't always 18.
Yeah.
It used to be 21. It was lowered to 18 by the 61st Constitutional Amendment Act back in 1988. That was a major change, significantly expanding who could vote and therefore the base of representation for the Lok Sabha.
And for the Union territories, representation is also direct?
Yes, the source mentions Parliament passed an act in 1965, the Union territories' Direct Election to the House of the People Act, to ensure they're chosen by direct election too.
Now, you mentioned nominated members for Rajya Sabha. Was there anything similar for Lok Sabha?
There was, actually. It's a fascinating historical point. Before 2020, the president could nominate up to 2 members from the Anglo-Indian community.
If they felt the community wasn't properly represented through the election.
Exactly. And the source defines Anglo-Indian, someone with European male lineage, born and living in India.
So what happened to that provision?
Well, it was initially only meant to last 10 years, up to 1960. But it kept getting extended again and again through amendments. Then, quite recently, the 104th Amendment Act in 2019 did something interesting. It extended the reservation of seats for scheduled castes and scheduled tribes.
Which we'll get to.
Yes, but at the same time, this amendment discontinued the Anglo-Indian nomination provision. That took effect in January 2020.
So one type of special representation extended, another ended by the same amendment. That's quite specific.
It really shows how ideas about representation can evolve and be adjusted over time.
The source also talks about uniformity of representation in the Lok Sabha. What does that mean?
It means constituencies are drawn up so that, as much as possible, the ratio between the population of each constituency and the number of seats it gets is the same across a state. And also that this ratio is uniform between different states, aiming for one person, one vote, having roughly equal weight, geographically speaking.
Does this mean constituencies change size?
Yes, it requires readjustment after every census to reflect population shifts. This is handled by delimitation commissions set up by Acts of Parliament.
But hasn't this been frozen sometimes?
It has. The source points out some interesting history here. The 42nd Amendment in 1976 actually froze the allocation of seats and the drawing of constituency boundaries based on the 1971 census figures, all the way until the year 2000.
Why would they do that? Freeze it for so long?
The thinking, according to the source, was partly linked to population control policies. The idea was to encourage states to implement family planning without them worrying that success would mean losing Lok Sabha seats due to a smaller population share.
Interesting incentive. And that freeze got extended.
It did. The 84th Amendment in 2001 extended the freeze on the number of seats allocated to each state until 2026. But a later amendment, the 87th in 2003, did allow the redrawing of constituency boundaries within states based on the 2001 census, just without changing the total number of seats each state had.
So complex adjustments trying to balance representation with other national goals?
Absolutely. It shows the dynamic nature of these rules.
Now, you mentioned the reservation of seats for scheduled castes and scheduled tribes.
Yes, this is another key feature. Seats are reserved for SCs and STs in the Lok Sabha in proportion to their share of the population in each state.
How are these seats filled? Is it a separate vote?
No, that's important. They are filled by direct election from those reserved constituencies, but all eligible voters in that constituency, regardless of caste or tribe, participate in the election. There's no separate electorate system. And members of SC and ST communities can also contest general unreserved seats.
And this reservation, like the Anglo-Indian one, was temporary initially.
It started out that way, yes, for 10 years, up to 1960. But it has been consistently extended by Parliament through various amendments ever since. The same 104th Amendment Act from 2019 that ended the Anglo-Indian nomination actually extended the SC-ST reservation until the year 2030.
That contrast again. Okay, finally, On Lok Sabha composition, the voting system used in the general election.
It uses territorial representation, specifically the first-past-the-post FPTP system.
Explain FPTP simply.
India is divided into lots of single-member constituencies. In each constituency, whichever candidate gets the most votes, even if it's not over 50%, just the highest number wins the seat. Simple majority wins the seat.
Which is different from the proportional representation used for Rajya Sabha state member.
Totally different. Proportional representation tries to make a party's share of seats match its share of the overall vote. FPTP doesn't guarantee that. A party can get a lot of votes spread out and win few seats, or win many seats with narrow majorities in each.
So why did the Constitution framers go with first past the post for the main elected house, the Lok Sabha?
The source gives two main reasons. First, practicality. Given the literacy levels at the time of independence, they felt proportional representation systems, which can be complex, might be too difficult for many voters to navigate.
And the second reason?
Governance stability. Proportional representation often leads to many small parties getting seats. This can make forming a stable government with a clear majority quite difficult in a parliamentary system like India's, potentially leading to frequent coalition collapses. First past the post, on the other hand, tends to magnify the winning party's majority, making it easier to form a stable government. That stability was seen as crucial.
Stability was the priority. Got it. Okay, let's move from who gets elected to who can be elected, qualifications and disqualifications for being a member of parliament.
The basics are pretty straightforward. You need to be a citizen of India, you have to take an oath or affirmation, and there's an age minimum. 30 years old for the Rajya Sabha and 25 for the Lok Sabha.
Tell me more about that oath.
It's taken before you can actually take your seat in the House. You swear it before someone appointed by the Election Commission. You pledge true faith and allegiance to the Constitution and promise to uphold the sovereignty and integrity of India. It's a formal commitment.
Can Parliament add more qualifications beyond these?
Yes. The Constitution allows Parliament to prescribe other qualifications by law, and they have, most notably through the Representation of People Act, 1951. This adds quite a few more conditions.
Like what sort of things?
Well, things relating to ethical conduct and background checks, essentially. You can be disqualified if you're found guilty of certain election offenses or corrupt practices, or if you've been convicted of a crime and sentenced to 2 or more years in prison, though being held under preventive detention doesn't count for this.
Okay.
Failing to file your election expenses on time can disqualify you. Holding certain financial interest in government contracts, or being a director or managing agent in a company where the government holds at least a 25% share, those are grounds too.
So avoiding conflicts of interest.
Exactly. Also being dismissed from government service for corruption or disloyalty, or being convicted for promoting hatred between groups, or for social crimes like untouchability, dowry, or sati. It's quite a list, and in ensuring some level of integrity.
Definitely comprehensive. Now, what about disqualifications mentioned directly in the Constitution itself?
The Constitution lists several. Holding an office of profit under the union or state government is a major one, though there are exceptions. Being declared of unsound mind by a court. Being an undischarged insolvent, basically, bankrupt and not yet cleared.
Okay.
Not being an Indian citizen, or having voluntarily acquired citizenship of another country, or acknowledging allegiance to a foreign state. And finally, being disqualified under any law made by Parliament, which loops back to things like the Representation of People Act we just discussed.
That office of profit sounds like it could be complicated. What exactly does it mean?
It generally refers to any position under the government, central or state, that brings some kind of financial gain, salary, or benefit. The idea behind disqualifying someone for holding such an office is to prevent conflicts of interest and ensure MPs aren't beholden to the executive through financial ties.
But there are exceptions.
Yes, the Constitution itself says Parliament can declare by law that holding certain offices does not disqualify a member. And importantly, holding the office of a minister is explicitly stated not to be an office of profit for this purpose.
What happens if there's a dispute about whether a member is disqualified on these grounds? Who decides?
The president makes the final decision. However, and this is crucial, the president is required to obtain the opinion of the Election Commission before making that decision and must act according to that opinion. So there's an independent body involved.
That brings up another big area of disqualification defection, changing parties. That's covered separately, right?
Yes, that's under the 10th schedule of the Constitution, often called the anti-defection law. It was added later to tackle political instability caused by legislators switching sides.
So when does it apply?
A member can be disqualified if they voluntarily give up the membership of the political party they were elected on, or if they vote or abstain from voting in the House, contrary to a whip issued by their party, without getting prior permission.
What about independent members?
An independent member gets disqualified if they join any political party after being elected. And for nominated members, they're disqualified if they join a party 6 months after they take their seat in the House. They have a 6-month window to decide, basically.
Who makes the call on these defection cases? Is it the president again?
No, this is different. For disqualification under the 10th schedule, the decision-making authority is the presiding officer of the House concerned, the chairman in the Rajya Sabha or the speaker in the Lok Sabha, not the president.
And can that decision be challenged in court?
Yes. Initially, the law tried to exclude judicial review, but the Supreme Court, in a very important case called Quijano-Holohan back in 1992, ruled that the decision of the speaker or chairman under the 10th schedule is subject to judicial review. So, courts can look into whether the decision was fair, legal, and followed proper procedure.
Okay, so disqualification is one way a seat becomes vacant. What are other ways?
Double membership is one. You can't be a member of both houses of parliament at the same time, nor can you be a member of parliament and a member of a state legislature simultaneously.
What happens if someone gets elected to both?
The Representation to People Act lays down the rules. For example, if someone is already a state legislator and then gets elected to parliament, their state seat automatically becomes vacant. If they are elected to both a state seat and a parliament seat around the same time, they generally have about 14 days to choose which one to keep. If they don't resign the state seat, their parliament seat might become vacant. There are specific timelines.
Resignation is obviously another way.
Yes, a member can simply resign by writing to the speaker, if in Lok Sabha, or the chairman, if in Rajya Sabha.
What about just not showing up?
That can lead to vacating the seat too. If a member is absent from all sittings of their House for a continuous period of 60 days without permission, the House itself can declare their seat vacant.
Any other circumstances?
Sure. If a court declares a member's election void, if the House itself expels a member, or if a member gets elected as president or vice president or appointed as a governor of a state, their seat in parliament becomes vacant.
You mentioned a court declaring an election void. How does that process work?
The Constitution itself doesn't lay out the procedure. That's, again, governed by the Representation of People Act, 1951. It gives the High Court the power to declare an election void if, for instance, the winning candidate was disqualified at the time of election. And there's a provision for appeal to the Supreme Court.
So, quite a few rules ensuring who sits in Parliament and under what conditions. Let's talk about compensation. How are MPs paid?
Their salaries and allowances are determined by Parliament itself through a law called the Salary, Allowances, and Pension of Members of Parliament Act, 1954. Interestingly, the original Constitution didn't mention pensions for MPs, but Parliament added that provision through an amendment in 1976.
Does the source give any actual figures?
It does, based on updates from 2018. At that time, the basic salary was increased to $1 lakh per month. On top of that, the constituency allowance went up to $70,000 per month, and the office expenses allowance to $60,000 per month. Plus, there's a daily allowance when attending sessions or committee meetings, which was increased to $2,000 per day.
And the pension amount?
As of 2018, an MP who served for any length of time was entitled to a pension of $25,000 per month. And for every year they served beyond the first 5 years, they got an additional $2,000 per month on top of that.
Are there other perks?
Yes, various facilities, travel allowances, accommodation in Delhi, telephone facilities, advances to purchase vehicles, medical facilities, and so on.
Now, what about the people running the show, the presiding officers? Are their salaries handled the same way?
No, there's a key difference. The salaries and allowances of the Speaker and Deputy Speaker of the Lok Sabha and the Chairman and Deputy Chairman of the Rajya Sabha are charged on the Consolidated Fund of India.
What does charged mean in this context?
It means these expenses don't need to be voted on by Parliament each year as part of the budget demands. They are considered non-votable expenditure. This provides a degree of financial independence for these key officers, shielding their compensation from political budget debates.
Does the source mention their salary levels?
Yes, again, as of 2018. The chairman of the Rajya Sabha, who is the vice president of India, saw a significant increase to $4 lakh per month. The other presiding officers, the Speaker, the Lok Sabha Deputy Speaker, and the Rajya Sabha Deputy Chairman received the same basic salary as regular MPs, the Euro lakh month figure.
But they get other allowances.
Yes, they generally get the same daily and constituency allowances as MPs. though the Rajya Sabha chairman doesn't get the constituency allowance. Plus, they receive a sumptuary allowance basically for hospitality expenses. The speaker gets an amount similar to a cabinet minister, 2,000 a month mentioned, and the deputy speaker and deputy chairman get an amount like a minister of state, over 1,000 a month mentioned.
Okay, those specifics help paint the picture. Let's focus now on these presiding officers themselves. Each house has its own leaders.
That's right. Lok Sabha has the speaker and deputy speaker. Rajya Sabha has the chairman and deputy chairman. And both houses also have panels of members who can step in to preside if needed.
Let's start with the Speaker of the Lok Sabha. How is the Speaker chosen?
The speaker is elected by the Lok Sabha members from amongst themselves. This usually happens soon after the first sitting of a newly elected Lok Sabha. The president fixes the date for this election.
And how long do they hold office?
Typically for the entire life of that Lok Sabha, so about 5 years, unless it's dissolved earlier.
Can they be removed?
Yes, they can vacate the office earlier under 3 conditions. If they cease to be a member of the Lok Sabha, if they resign by writing to the deputy speaker, or if they're removed by a resolution passed by the Lok Sabha.
Removal requires a special type of majority.
Yes, the source specifies an effective majority. That means a majority of all the then members of the House, not just those present and voting, but a majority of the total current strength, excluding vacancies. And you need to give 14 days advance notice before moving such a resolution.
What happens when that removal resolution is being debated? Can the Speaker preside?
No, they cannot preside over the sitting when their own removal is being considered. However, they can be present, speak, participate in the debate, and importantly, they can vote in the first instance just like any other member. But they lose their casting vote power during that specific vote.
Here's something interesting the source notes. The Speaker doesn't leave office right when the Lok Sabha is dissolved.
That's a really important point for continuity. The Speaker actually continues to hold office even after dissolution, right up until the first meeting of the newly elected Lok Sabha.
Why is that?
It ensures there's someone formally in charge of the House's affairs and secretariat during the interim period between one Lok Sabha ending and the next one beginning. Administrative and procedural continuity.
What are the Speaker's main powers and functions? They seem quite central.
They really are. The Speaker is seen as the principal spokesperson of the House, representing its collective voice and authority. They're the guardian of the powers and privileges of the House and its members.
Any specific key powers?
A very significant one is that their decision on whether a particular bill is a money bill is final. It can't be challenged anywhere. They also preside over joint sittings of both houses if one is called. Domestically, they maintain order and decorum during proceedings, interpret the rules, and can adjourn or suspend sittings, like if there's no quorum.
What about voting?
When presiding, the Speaker does not vote in the first instance. They only exercise a casting vote if there's a tie and equality of votes.
The source really stresses the need for the Speaker to be independent and impartial.
Absolutely critical. Their conduct can't just be debated casually. It requires a substantive motion. And their powers related to conducting business within the House are generally protected from judicial interference. The source even quotes former President V.V. Gary, emphasizing how vital impartiality is for the Speaker to function effectively as the House's guardian.
Okay, what about the Deputy Speaker of the Lok Sabha?
Also elected by the Lok Sabha members from amongst themselves, usually after the Speaker's election. The Speaker fixes the date for this election. Like the Speaker, they typically hold office for the life of the Lok Sabha.
And the conditions for vacating office are similar?
Yes, same 3. Ceasing to be a member, resigning, they resign to the Speaker, or being removed by a resolution passed by an effective majority, again with 14 days' notice.
What are their duties?
They step in and perform the Speaker's duties whenever the Speaker's office is vacant or when the Speaker is absent from a sitting. And crucially, when they're acting as Speaker, they have all the powers of the Speaker.
Including presiding over a joint sitting if the Speaker can't.
Yes. And the source makes a point that the Deputy Speaker isn't subordinate to the Speaker. They are directly responsible to the House itself.
Is there a special privilege mentioned for the Deputy Speaker?
Yes, an interesting one. If the Deputy Speaker is appointed as a member of any parliamentary committee, they automatically become its chairman. That's unique to the office.
Their voting rights when presiding.
Same as the Speaker.
Yeah.
No vote in the first instance, only a casting vote in case of a tie.
But when the Speaker is presiding...
Then the Deputy Speaker functions just like any other ordinary member. They can speak, participate in debates, and vote in the first instance. Their salary is also fixed by Parliament and charged on the consolidated fund.
Is there convention about which party the speaker and deputy speaker come from?
Yes, there's a long-standing convention, though the source notes it hasn't always been followed. Usually, the speaker comes from the ruling party or coalition, while the deputy speaker is chosen from the main opposition party. It's meant to foster a sense of fairness and balance.
Beyond these two, there's a panel of chairpersons.
Correct. The speaker nominates up to 10 members to this panel. Any one of them can preside over the House if both the speaker and deputy speaker are absent. When presiding, they have the same powers as the speaker.
But they can't preside if the offices are actually vacant.
Exactly. If both the speaker and deputy speaker positions are vacant, then the president appoints a member of the Lok Sabha to perform the speaker's duties until the vacancies are filled through election. The panel of chairpersons only covers temporary absence.
And who is the speaker pro tem?
That's a temporary role right at the beginning of a new Lok Sabha. After an election, the previous speaker vacates office just before the first sitting. The president then appoints a speaker pro tem, usually the most senior member of the newly elected House. Their only job is to preside over that first sitting, administer the oath to new members, and oversee the election of the new speaker. Once the new speaker is elected, the speaker pro tem's role ends.
Okay, that clarifies the Lok Sabha leadership. Now, onto the Rajya Sabha. The chairman is different.
Very different. The chairman of the Rajya Sabha is the vice president of India, acting in an ex officio capacity. They aren't elected by the Rajya Sabha itself.
What if the vice president is acting as president?
Then they don't perform the duties of the chairman of the Rajya Sabha during that period. And they can only be removed as chairman if they're removed from the office of vice president through the proper constitutional process.
Are their powers similar to the speaker's?
Generally, yes, within the context of presiding over the Rajya Sabha, maintaining order, interpreting rules, casting vote in a tie, etc. However, the source points out two crucial powers the speaker has that the chairman lacks.
Which are?
First, only the speaker can certify a bill as a money bill. The chairman doesn't have that power. Second, it's the speaker who presides over a joint sitting of both houses. The chairman doesn't.
Any other differences?
Yes, regarding removal. We noted the speaker can vote in the first instance when their removal is debated. The chairman, however, cannot vote at all in the Rajya Sabha when a resolution for their removal as vice president is under consideration.
Their salary is also charged on the consolidated fund.
Yes, but if the vice president is acting as president, they get the president's salary and allowances, not the chairman's.
And the deputy chairman of the Rajya Sabha.
Now, they are elected by the Rajya Sabha members from amongst themselves, similar to the deputy speaker in Lok Sabha.
And vacate office under similar conditions.
Yes, ceasing to be a Rajya Sabha member, resigning to the chairman, or being removed by a resolution passed by an effective majority of the Rajya Sabha with 14 days' notice.
Their role.
They perform the chairman's duties if the chairman's office is vacant, or if the vice president is acting as president, or if the chairman is absent from a sitting. When presiding, they have all the chairman's powers.
And like the deputy speaker, not subordinate.
Correct. Not subordinate to the chairman, directly responsible to the Rajya Sabha. They have only a casting vote when presiding and are an ordinary member when the chairman presides. Their salary is also fixed by Parliament and charged on the consolidated front.
Rajya Sabha also has a panel for presiding.
Yes, a panel of vice chairpersons, nominated by the chairman, who can preside if both the chairman and deputy chairman are absent. Same principle as in the Lok Sabha.
Lastly, on structure, the secretariat.
Each House, Lok Sabha, and Rajya Sabha has its own independent secretarial staff. They handle all the administrative and support functions. Each secretariat is headed by a secretary general who is a permanent officer appointed by the presiding officer of that house. Their recruitment and service conditions are regulated by Parliament.
Okay, that covers the structure, members, and officers thoroughly. Let's get into the rhythm of how Parliament actually works its sessions and proceedings. How often does it meet?
The president is the one who summons each house to meet. The key constitutional rule is that the gap between two sessions cannot be more than 6 months.
So Parliament must meet at least twice a year.
At a minimum, yes. But typically, there are 3 sessions in a calendar year.
The ones we usually hear about.
Exactly. The budget session, which is the longest, usually running from February to May, then the monsoon session, typically July to September, and the winter session, usually November to December.
The source defines session versus recess.
Right. A session covers the whole period from the first day the House sits after being summoned, right up until it's either prorogued or, in the case of Lok Sabha, dissolved. The recess is simply the time gap between the prorogation of one session and the start of the next session.
Now, during a session, the daily sittings can be ended in different ways. Adjournment sine die.
Let's clarify those. Adjournment is the simplest. It just suspends the work of the House for a specific stated time, could be a few hours, a day, or even several days or weeks within the same session. This is done by the presiding officer, speaker, or chairman.
And adjournment sine die, that sounds more final.
Sine die means without a day. So adjourning sine die means ending a sitting for an indefinite period without fixing a specific date for the House to meet again. This is also done by the presiding officer. However, they retain the power to call a sitting at any time, even after adjourning sine die, if needed before the session is formally ended.
Which brings us to prorogation. That ends the session itself.
Exactly. Prorogation terminates the entire session, not just a sitting. This power belongs to the president, not the presiding officer. Usually the president issues the prorogation order after presiding officer has adjourned the House sine die, but the president can prorogue the session even while the House is technically still sitting.
So, key difference. Adjournment ends a sitting, presiding officer. Prorogation ends a session, president.
That's the core distinction, and neither adjournment nor prorogation kills pending bills or other substantive business before the House. That carries over.
But something does lapse on prorogation?
Yes, pending notices. Things like notices of questions members wanted to ask, motions they intended to move, resolutions they submitted. Unless it's a notice to introduce a bill, all those lapse. They have to be submitted afresh in the next session. This is different, the source notes, from the UK practice, where prorogation historically ended almost all pending business, including bills.
And then the most drastic end, dissolution, only for Lok Sabha.
Right. Dissolution ends the very life of the Lok Sabha. The House ceases to exist, and a new one has to be formed through general elections. The Rajya Sabha, being the permanent House representing states, is never dissolved.
How does dissolution happen?
Two ways. Either automatically, when the Lok Sabha completes its normal 5-year term, or any extended term granted during an emergency, or the president can decide to dissolve the Lok Sabha earlier than its full term, usually on the advice of the prime minister. The source says this decision by the president is irrevocable.
What's the impact of dissolution on parliamentary business? This must be huge.
It is. Dissolution causes all business pending before the Lok Sabha or any of its committees to lapse. That includes bills, motions, resolutions, notices, petitions, everything. If it was pending in Lok Sabha, it's gone. It has to be reintroduced from scratch in the new Lok Sabha after the election.
Are there any exceptions at all? Does anything survive dissolution?
A few things do. The source mentions that some specific categories of pending bills might not lapse, depending on their exact status, which we can get into. And significantly, all pending assurances given by ministers on the floor of the House, which are monitored by the Committee on Government Assurances, do not lapse. That committee's work continues across dissolutions.
Okay, let's nail down those rules about which bills lapse and which don't. That seems crucial.
Right. Rule 1. Any bill that is pending in the Lok Sabha lapses. Doesn't matter if it started there or came from the Rajya Sabha. If it's physically with the Lok Sabha when dissolution happens, it's gone.
Okay.
Rule 2. Any bill that has been passed by the Lok Sabha but is pending in the Rajya Sabha also lapses, because the Lok Sabha that passed it no longer exists.
What if the two houses disagreed on a bill and a joint sitting was planned?
That's a key exception. If a bill has passed one house, gone to the other, and a deadlock has arisen, like the second house rejected it or amended it unacceptably or sat on it for 6 months, and the president has already notified their intention to call a joint sitting before the Lok Sabha is dissolved, then that bill does not lapse. The joint sitting can still happen with the new Lok Sabha.
What about bills that are only in the Rajya Sabha pipeline?
If a bill is pending in the Rajya Sabha but has not yet been passed by the Lok Sabha, it does not lapse. Because the Rajya Sabha is a continuing body, its own pending business survives.
And bills that have finished the parliamentary process?
If a bill has been passed by both houses and is just waiting for the president's assent, it does not lapse. Similarly, if a bill was passed by both houses, sent to the president, and the president returned it for reconsideration, that bill also does not lapse. It can be reconsidered by the new Lok Sabha.
Those rules are complex but very important for legislative continuity.
Okay, moving to the actual conduct of business. Quorum, the minimum number needed. Yes, for the House to legally do anything, a minimum number of members must be present. The Constitution sets this quorum at 1/10 of the total membership of the House, and this includes the presiding officer and the count.
So for the current Lok Sabha, Strength 533.
1/10 is roughly 54. So quorum is 55 members, including the speaker person presiding.
And for Rajya Sabha, strength 245.
1/10 is about 24.5. So quorum is 25 members, including the chairman, deputy chairman person presiding.
What happens if there's no quorum?
The presiding officer has a duty either to adjourn the House or to suspend the sitting until there's a quorum. No business can be transacted without it.
How are decisions typically made? Voting.
Yes, most decisions are made by a majority of the members who are present and voting on that particular matter. This is the standard simple majority. Things needing a higher threshold, like an effective or special majority, are specifically laid out elsewhere in the Constitution or rules.
And the presiding officer's role in voting.
As we mentioned, they don't vote in the first instance. They only get to vote if there's a tie, an equal number of ayes and noes. In that case, they exercise a casting vote to break the tie.
What if someone votes who shouldn't have, or there's a vacancy? Does it invalidate the decision?
No, the source explicitly says the validity of any proceedings in Parliament cannot be questioned just because some unauthorized person participated or voted, or because there was a vacancy in the membership at the time.
The source describes the voting process in the Lok Sabha. How does it work?
It usually starts with a voice vote. The speaker puts the question and asks members in favor to say aye and those against to say no. Based on the voices, the speaker announces the result.
What if someone challenges that?
If the speaker's decision on the voice vote is challenged, they order a division. First, the lobbies, areas outside the chamber, are cleared for about 3.5 minutes to ensure only members are present. Then the question is put again. If the challenge persists, the votes are formally recorded.
How are votes recorded?
The main method now is the automatic vote recording system, where members press buttons at their seats. But the source mentions other methods too. Sometimes votes are recorded using slips of paper. The old method of members physically going into the aye or no lobbies is apparently obsolete now.
Any other ways?
Yes. For certain secret votes, like elections within the House, a system using lights might be used. Recording by slips is also a backup if the automatic system fails, or used right at the beginning of a new Lok Sabha before seat numbers are assigned for the electronic system. And sometimes, if the speaker thinks a formal division isn't really necessary after a voice vote challenge, they can just ask members for and against to stand up for a quick head count. Names aren't recorded in that case. Plus, of course, the presiding officer's casting vote if needed.
What about the language used in Parliament? Is it just Hindi and English?
The Constitution says business shall be transacted in Hindi or English. However, it also empowers the presiding officer of either house to permit a member who can't adequately express themselves in Hindi or English to speak in their mother tongue.
Is the translation?
Yes. The source mentions that arrangements exist for simultaneous interpretation into Hindi and English for speeches made in languages listed in the 8th schedule of the Constitution.
Wasn't English supposed to be temporary?
Initially, yes. The Constitution allowed English to be used alongside Hindi for 15 years from its commencement, so until 1965. But the Official Languages Act of 1963 was passed by Parliament to provide for the continued use of English, along with Hindi, for official purposes and parliamentary business, even after 1965, indefinitely. So both remained the language of the business.
Okay. This talk of voting brings us neatly to the different types of majorities needed. It's not always just more ayes than noes.
Absolutely not. The Constitution and rules specify different thresholds for different actions, reflecting varying levels of significance or consensus required.
Let's start with the most basic, simple majority.
This is the one we just discussed. It means a majority of the members who are present in the House and actually voting on the matter. You ignore abstainers. It's sometimes called the ordinary majority, or functional or working majority. Article 100 says this is the default unless otherwise specified.
And the source gives lots of examples where this applies.
Yes, it's used for most ordinary things. Passing ordinary bills, money bills, financial bills, unless they also need a special majority for some reason. Passing motions like adjournment, no confidence, confidence, censure motions. Passing the motion of thanks on the president's address.
What else?
Approving the proclamation of president's rule or a financial emergency. Electing the speaker and deputy speaker of the Lok Sabha. Electing the deputy chairman of the Rajya Sabha, even for the Lok Sabha to pass a resolution disapproving the continuation of a national emergency, and interestingly, for the Lok Sabha to agree to the removal of the vice president after the Rajya Sabha has passed its resolution. It's the standard majority for most parliamentary business.
Okay, next level up, effective majority.
This one is calculated differently. It means a majority of the total membership of the House minus the number of vacant seats. So it's a majority of the effective strength of the House at that time. The Constitution sometimes refers to this as a majority of all the then members of the House.
Can you give an example?
Sure. Say the Rajya Sabha has a total sanctioned strength of 245, but maybe 10 seats are currently vacant due to deaths or resignations. The effective strength is 245, 10 equals 235. An effective majority would then be more than half of 235, which is 118.
And where is this specific majority required?
It's primarily used for the removal of certain key office holders. Specifically, the removal of the vice president and the Rajya Sabha. Remember, Lok Sabha only needs simple majority to concur. Also, the removal of the deputy chairman of the Rajya Sabha and the removal of the speaker and deputy speaker of the Lok Sabha. It's a higher bar than simple majority used for these specific internal removals.
Then there's absolute majority.
This means a majority of the total membership of the House, period. Regardless of vacancies or how many people are absent or voting, it's more than half of the full sanctioned strength of the House.
So, fixed numbers.
Yes. For the Lok Sabha, with its total strength of 543, the absolute majority is 272, which is 500 and 432 plus 1, rounded up. For the Rajya Sabha, with its total strength of 245, the absolute majority is 123, 200 and 452 plus 1, rounded up.
Is absolute majority ever required on its own?
According to the source, no. It's not a standalone requirement for passing any specific bill or motion. However, it often forms one part of the requirement for certain types of special majorities.
Right, which brings us to special majority. The source says this isn't just one thing.
Correct. Special majority is a general term, and the exact requirement depends on the specific articles of the Constitution being invoked. There are at least 3 main types mentioned or implied.
What's the most common type, maybe, for amending the Constitution?
Yes. For most Constitution Amendment bills under Article 368, you need a majority of the total membership of the House. That's the absolute majority we just discussed. And a D, a majority of not less than 2/3 of the members of that House present and voting. Both conditions must be met in each House separately.
That's a significantly high threshold.
It is. Then there's another type of special majority that only requires a majority of not less than 2/3 of the members present and voting. You don't need the absolute majority condition for this type.
Where is that used?
This is required for some very specific, important actions. For example, for Parliament to pass resolutions needed for the impeachment process of Supreme Court or High Court judges, or the removal of the Chief Election Commissioner or the Comptroller and Auditor General, CAG. It's also the majority needed in the Rajya Sabha to pass those special resolutions under Article 249, allowing Parliament to legislate on a stateless subject, or Article 312, allowing Parliament to create new all-India services. These are unique powers requiring this specific 2/3 present and voting majority.
And the third type, for amending federal parts of the Constitution.
That's the toughest. It requires the special majority, mentioned first, absolute majority plus 2/3 present and voting, in each House of Parliament. PLUS ratification by the legislatures of at least half of the states, with those state legislatures passing the ratification by a simple majority. This reflects the federal nature of the change.
So the type of majority needed really tells you something about the constitutional weight of the decision being made.
Precisely. It's a built-in way to ensure different levels of consensus for different actions.
Okay, let's shift from the how of voting to the what of daily business. The devices Parliament uses to discuss issues, ask questions, hold the government accountable.
Right. These are the specific procedural tools members use to raise matters, initiate debates, and basically do their job of oversight and deliberation.
We hear a lot about question hour. It's the first hour.
Yes. Typically, the first hour of every sitting, usually 11 a.m. to 12 noon, is reserved for question hour. It's a really vital tool for accountability. Members ask questions directed at ministers about government policies, actions, and administration.
And ministers have to answer.
Yes, they are obligated to answer, usually orally, right there on the floor of the House. The great thing about oral answers is that they allow the member who asked, and sometimes other members, to ask follow-up supplementary questions for further clarification.
Are all questions answered orally?
No, there are different types. Starred questions are the ones intended for an oral answer, hence the supplementaries. They're marked with an asterisk. Unstarred questions get a written answer from the minister, which is laid on the table of the House later. No supplementaries are allowed for these. Then there are short notice questions, which relate to urgent public matters and can be asked with less than the usual 10 days notice. These are also answered orally.
Can a member ask a question to another member who isn't a minister?
Yes, it's possible to ask a question to a private member a non-minister MP, but only if the subject matter relates directly to some bill, resolution, or other business that specific private member is responsible for in the House.
The source even mentions color coding for the question lists.
Yeah, yes. Apparently, the printed lists have different colors. Green for starred, white for unstarred, light pink for short notice, and yellow for questions to private members, at least in the Lok Sabha example given. A small detail, but shows the systematization.
What happens right after question hour?
That's when 0 hour begins. And this is quite unique.
How so?
It's an informal device. It's not mentioned in the official rules of procedure of the Houses. It's purely an Indian parliamentary innovation, apparently started around 1962.
And what's its purpose?
It's the time slot immediately after question hour ends, around 12 noon, and lasts until the regular scheduled business, the agenda for the day, begins. Members use this time to raise matters they consider extremely important and urgent, without needing to give any advance notice. It allows for spontaneity in raising pressing issues.
So, question hour is formal, 0 hour is informal, both for raising issues. What about formal debates?
For a substantial discussion on a matter of general public importance, you generally need a motion. A member has to propose a motion, get the presiding officer's consent, and if the House adopts the motion, a discussion follows. Motions are the way the House formally expresses its decisions or opinions.
The source categorizes motions.
Yes. Substantive motions are self-contained, independent proposals dealing with significant matters like impeachment or removal of officers. Substitute motions are moved as an alternative to an original motion. If adopted, they replace the original one. Subsidiary motions depend on or relate to another motion or preceding things like amendments to a motion or a motion to adjourn debate.
There's a specific calling attention motion.
All right, this is another Indian innovation from 1954. It allows a member, with his speaker chairman's prior permission, to call the attention of a minister to a matter of urgent public importance. The minister is then expected to make a brief authoritative statement on that matter. Unlike 0 hour, this is mentioned in the rules of procedure.
Then there's the adjournment motion. The source calls this an extraordinary device. Why?
Because its main purpose is to interrupt the normal scheduled business of the House to discuss a definite matter of urgent public importance that has suddenly arisen. It's considered extraordinary because it sets aside the planned agenda.
Does it need support?
Yes. To be admitted, an adjournment motion needs the support of at least 50 members who rise in their places, and its adoption is seen as a form of censure against the government for failing to anticipate or handle the urgent matter raised.
Censure? That sounds serious.
It is. Because of this potential censure element and its disruptive nature, the Rajya Sabha is not allowed to use the adjournment motion device. Only the Lok Sabha can. If admitted, the discussion usually lasts for at least 2.5 hours.
Are there strict rules for what qualifies?
Very strict. The matter must be definite, factual, urgent, and of public importance. It must cover only one specific issue. It should be about a recent event. It cannot raise a question of privilege, revive discussion on something already debated in the same session, relate to expenditure charged on the consolidated fund, or deal with matters under court adjudication. These tight restrictions ensure it's used only for genuinely exceptional circumstances.
And if an adjournment motion passes in the Lok Sabha?
The source suggests that, like a censure motion, its passage is seen as expressing a lack of confidence in the government, potentially leading to resignation. It's a powerful accountability tool.
Which leads us to the ultimate expression of lack of confidence, the no confidence motion.
This motion, moved under Article 75 of the Constitution, directly states that the Lok Sabha has no confidence in the entire Council of Ministers. If this motion is passed, the government must resign. It also requires the support of 50 members to be admitted for discussion. This is the fundamental mechanism by which the Lok Sabha holds the executive accountable.
Is there an opposite motion?
Yes, a confidence motion.
Yeah.
This is typically moves by the government itself, usually when its majority is in doubt, to proactively prove that it still commands the confidence of the Lok Sabha.
What about a censure motion? How is that different from no confidence?
A censure motion is moved to express strong disapproval or condemnation of a specific policy or action of an individual minister, a group of ministers, or the entire Council of Ministers. Unlike a no-confidence motion, it must state the reasons or grounds for the censure. Also, while its passage is politically damaging and might lead a government to resign, it does not automatically or constitutionally compel the government to resign in the way a no-confidence motion does.
Okay, that's a clear distinction. The motion of thanks also relates to confidence.
Yes, indirectly. After the president's address at the start of a new parliament or the first session of the year, outlining government policy, both houses debate it and vote on a motion of thanks. Amendments can be proposed to this motion.
What if the motion of thanks is defeated in the Lok Sabha?
That's considered a major blow. The source states clearly that the defeat of the motion of thanks in the Lok Sabha amounts to a defeat of the government, signaling a lack of confidence and likely leading to its resignation.
Are there other ways to initiate discussion?
Several. A no day yet named motion is one that the speaker admits but doesn't immediately schedule. A date is fixed later. A dilatory motion is purely procedural, aimed at adjourning debate or delaying business. The speaker can allow it or rule it out if it's just wasting time.
What about shorter discussions?
There's a half-an-hour discussion, usually held on 3 days a week, for members to seek further clarification on matters arising from answers to questions. No formal motion or voting. There's also a short-duration discussion, also called a 2-hour discussion, in practice since 1953, allowed typically 2 days a week for discussing urgent public matters, again without a formal motion or voting.
And if a matter doesn't fit any of these?
Members can raise issues through special mention in the Rajya Sabha, or under notice mention, under Rule 377 minutes in the Lok Sabha. These are catch-all mechanisms for drawing attention to matters not covered elsewhere.
Finally, resolutions. How are they different from motions?
A resolution is a specific type of substantive motion. It's a self-contained proposal put forward for the House to vote on, expressing a formal opinion, recommendation, or decision. All resolutions are motions, but not all motions are resolutions. Many are procedural. A key difference is that all resolutions require a vote, whereas many motions, like for discussion, do not necessarily lead to a vote.
What are resolutions used for?
Various purposes: declaring the House's opinion, making a recommendation, approving or disapproving a government action, conveying a message, requesting action, or simply drawing attention to a public issue.
Are there different kinds?
Yes, categorized mainly by who moves them. Private members' resolutions are moved by MPs who aren't ministers, usually discussed on alternate Friday afternoons. Government resolutions are moved by ministers, often seeking approval for things like treaties, policies, or committee reports. Statutory resolutions are those required under a specific provision of the Constitution or an Act of Parliament. These can be moved by either a minister or a private member.
Okay, that covers the toolkit members have. Now, the core function, making laws. Let's walk through the legislative procedure. How does a bill become an act?
Right. The process for turning a legislative proposal, a bill, into an actual law, an act, is quite detailed and follows similar stages in both houses.
First, bills themselves are categorized.
Yes, in a couple ways. One is based on who introduces them. You have public bills, also known as government bills. These are introduced by a minister.
And they reflect government policy.
Exactly. They reflect the ruling government's agenda, so they generally have a much higher chance of getting passed. And, crucially, if a government bill is defeated in the Lok Sabha, it implies a lack of confidence in the government, possibly leading to resignation. They require 7 days' notice and are drafted by the relevant government department with the law ministry.
And the alternative?
Private bills, or more accurately, private members' bills. These are introduced by any MP who is not a minister. They usually reflect the views of the opposition or an individual member's specific concern or proposal.
Do they often pass?
Much less likely to be approved, as they don't have automatic government backing. Their rejection has no impact on the government's stability. They require a longer notice period, 1 month, and the member introducing it is responsible for drafting it. The source likely has a table comparing these.
Bills are also classified by content and nature?
Yes. By content. Original, brand new law, amending, changing an existing law, consolidating, combining several laws on a subject, expiring laws, continuance, extending temporary laws, repealing, canceling old laws. By nature, ordinary bills, money bills, Article 110, financial bills, Article 117, Types I and II, and Constitution Amendment bills. Each of these categories can have slightly different procedural paths.
Let's trace the path of an ordinary bill. The source says 5 stages in each house.
Broadly, yes, grouped into 3 readings. Stage 1 is the first reading. This is basically the introduction of the bill. A member, minister or private member, asks for leave of the House to introduce it, usually granted routinely. If the bill has already been published in the official gazette before introduction, leave isn't even needed.
What happens then?
The member reads the title and briefly states the objectives. There's no debate at this stage. The bill is then formally introduced and published in the gazette. That's it for the first reading.
Stage 2 is the second reading. The source calls this the most crucial.
It is, because this is where the detailed examination happens. It actually has substages. First, there's the stage of general discussion. Here, the House discusses the principles and overall provisions of the bill. They don't go into clause-by-clause detail yet.
What happens after this general discussion?
The House has options. It can decide to take the bill into consideration clause by clause immediately, or schedule it for later. Or, more commonly for complex bills, it can refer the bill to a committee.
Which committee?
It could be a select committee composed only of members from that specific House. Or it could be a joint committee with members drawn from both Lok Sabha and Rajya Sabha. Another option, though less common, is to circulate the bill to gather public opinion.
Okay, so if it goes to committee, that's the next substage.
Yes, the committee stage. The committee, select or joint, examines the bill thoroughly, clause by clause. They can hear from experts, stakeholders, and government officials. They can propose amendments to the clauses, but they're not supposed to alter the fundamental principles already approved by the House during the general discussion.
Then the committee reports back.
Exactly. The committee submits a report to the House, usually including the bill, as amended by them.
Then comes the consideration stage.
Right. Now, the House takes up the bill as reported by the committee, or as it was after the general discussion if it didn't go to committee. This is where the House considers the bill clause by clause. Each clause is discussed, amendments can be moved by any member, and each clause, with any accepted amendments, is voted upon. This is the detailed legislative scrutiny by the whole House.
After all clauses are done, stage 3 is the third reading.
This is the final stage in the first House. The debate now is restricted to arguments for or against passing the bill as a whole, in its final amended form. No further amendments to clauses are allowed. If the motion that the bill be passed is adopted by a simple majority of members present and voting, the bill is considered passed by that House.
Then what?
The presiding officer authenticates the passed bill, and it's formally transmitted to the second House.
And the second House goes through the same 3 stages.
Essentially, yes. First reading, introduction receipt. Second reading, general discussion, possibly committee clause-by-clause consideration. And third reading, final vote on the whole bill.
What can the second House decide to do?
It has 4 main options, according to the source. 1, pass the bill exactly as received from the first House. 2, pass the bill with amendments and send it back to the first House for agreement. 3, reject the bill outright. 4, take no action at all, effectively letting it sit pending indefinitely.
What happens if they pass it without changes, or if the first House agrees to the second House's amendments?
In either of those cases, the bill is considered passed by both houses in the same form. It's then ready to be sent to the president for assent.
But what if they disagree? The first House rejects the second House's amendments, or the second House just rejects the bill, or takes no action for 6 months.
That creates a deadlock between the 2 houses.
And how is a deadlock on an ordinary bill resolved?
The Constitution provides a mechanism. The president can summon a joint sitting of both the Lok Sabha and the Rajya Sabha under Article 108 to deliberate and vote on the bill together.
Who presides over this joint sitting?
The Speaker of the Lok Sabha presides. If the Speaker is absent, the Deputy Speaker of the Lok Sabha presides. If both are absent, the Deputy Chairman of the Rajya Sabha presides. The Chairman of Rajya Sabha, being the VP, doesn't preside.
How is a decision made in a joint sitting?
By a simple majority of the total number of members of both houses who are present and voting at the sitting.
Does this joint sitting mechanism apply to all bills?
No. This is crucial. Joint sittings can only be called for ordinary bills and some types of financial bills. They cannot be used for money bills, where Lok Sabha has the final say anyway, or for Constitution amendment bills, which require separate special majorities in each house.
What if the Lok Sabha gets dissolved after a deadlock arises, but before the joint sitting is held?
If the president had already notified his intention to summon a joint sitting before the dissolution, then the bill doesn't lapse, and the joint sitting can still be held with the members of the Rajya Sabha and the newly elected Lok Sabha. But if the notification hadn't happened before dissolution, the bill lapses if it originated in or was pending in Lok Sabha, and no joint sitting occurs.
Given Lok Sabha's larger size, does it usually get its way in a joint sitting?
Generally, yes. Since decisions are by simple majority of the combined membership present and voting, the Lok Sabha's numerical superiority, currently 543 versus 245, usually means its position prevails if the parties vote along House lines.
Can new amendments be proposed at the joint sitting?
Usually not. Amendments are generally limited to those points that cause the original disagreement between the houses or amendments made necessary by the delay. You can't reopen the whole bill for amendment.
Has this joint sitting mechanism been used often?
Very rarely. The source mentions it's only been invoked 3 times since independence. For the Dowry Prohibition Bill in 1960, the Banking Service Commission Repeal Bill in 1977, and the Prevention of Terrorism Bill, POTA, in 2002. It's clearly a last resort.
Okay, so once a bill clears both houses, separately or jointly, it goes to the president for the final step, assent, Article 111.
Right. The president has 3 options when an ordinary bill is presented. 1, give assent. The bill becomes an act, a law. 2, withhold assent. The bill does not become law. It's effectively vetoed. An absolute veto, though rarely used like this for ordinary bills by convention. 3, return the bill for reconsideration. The president can send the bill back to Parliament with a message requesting they reconsider it, perhaps suggesting amendments.
Can the president return any bill for reconsideration?
Not money bills. Money bills cannot be returned for reconsideration. The president can only give or withhold assent. For ordinary bills, they have the return option.
What if Parliament reconsiders the bill after the president returns it and passes it again?
If the houses pass the bill again, either with or without accepting the president's suggested changes and present it back to the president must give assent the second time around. They cannot withhold it or return it again.
So the return power is more like a delay or a request to rethink, not a final block.
Exactly. That's why it's often called a suspensive veto for ordinary bills. Parliament can override it by passing the bill again.
We should probably quickly touch on money bills and financial bills again here, as their procedures are different and really highlight Lok Sabha's power.
Definitely. A money bill under Article 110 deals only with specific financial matters, taxation, government borrowing, managing the consolidated or contingency funds, appropriation of money from the consolidated fund, expenditure charged on it, or managing the public account. It's a narrow definition. Bills about fines or local taxes aren't money bills.
And who decides if a bill fits this narrow definition?
Crucially, the Speaker of the Lok Sabha has the sole final authority to certify if a bill is a money bill. Their decision cannot be questioned anywhere, not in court, not by the Rajya Sabha, not even by the president.
And the procedure itself heavily favors Lok Sabha.
Completely. A money bill can only be introduced in the Lok Sabha and only on the prior recommendation of the president. Once passed by Lok Sabha, it goes to Rajya Sabha, but Rajya Sabha has very limited power.
What can Rajya Sabha do?
It cannot amend or reject a money bill. It can only discuss it and make recommendations for changes. And it must return the bill, with or without recommendations, to the Lok Sabha within 14 days.
What if Rajya Sabha makes recommendations? Is Lok Sabha bound by them?
Not at all. The Lok Sabha is free to accept or reject any or all of the Rajya Sabha's recommendations. Either way, the bill is then deemed to have been passed by both houses in the form finally approved by the Lok Sabha. If Rajya Sabha doesn't return the bill within 14 days, it's automatically deemed passed anyway, as originally sent by Lok Sabha.
So no deadlock possible, no joint sitting needed. Lok Sabha's will is supreme on money bills.
Precisely. And when a money bill goes to the president, they can give assent or withhold assent, but they cannot return it for reconsideration, since it originated with their recommendation. Assent is usually given.
What about financial bills that aren't strictly money bills?
Right. Those fall under Article 117. Financial bills, Type 1, under 117.1, contain some money matters but also other provisions. Like money bills, they can only be introduced in Lok Sabha on the president's recommendation. But after introduction, they follow the procedure of an ordinary bill, meaning Rajya Sabha has amendment powers and a joint sitting is possible if there's a deadlock.
And Type 2?
Financial bills, Type 2, under 117.3, contain provisions involving expenditure from the consolidated fund, but don't fall under the money bill definition. These can be introduced in either house and follow the ordinary bill procedure. However, they do require the president's recommendation before either house can consider passing them, not for introduction, but for the consideration stage. So different financial flavors get different procedural treatments.
That level of detail really underscores the constitutional design around financial matters. Let's broaden out now to Parliament's overall role in finances, especially the budget.
Okay, the Constitution in Article 112 actually calls it the annual financial statement. Budget is the popular term we all use.
And what exactly is it?
It's the government's statement of estimated income, receipts, and spending expenditure for the upcoming financial year, which in India runs from April 1st to March 31st.
Does it contain more than just numbers?
Well, yes. It typically includes proposals for raising revenue taxes, compares estimates with the past year's actual figures, explains any deficit or surplus, outlines the government's economic and financial policies for the year ahead, details specific taxation changes, lays out the spending programs for various ministries, and introduces any new schemes or initiatives.
The source mentioned something about the railway budget being separate previously.
That's right. For many decades, from 1924 until 2017, India had a separate railway budget presented before the main general budget. This was based on recommendations from the Ackworth Committee way back, mainly to give the railways more financial autonomy and treat them like a commercial undertaking.
But that changed.
Yes, in 2017, the government decided to merge the railway budget back into the main union budget. So now there's just one consolidated budget presentation covering everything.
The Constitution itself has quite a few specific rules about the budget process, doesn't it?
It does. Article 112 says the president must have the statement laid before both houses. Article 113 requires the president's recommendation for any demand for a grant, request for funds. Article 114 is key. No money can be withdrawn from the consolidated fund without an appropriation act passed by Parliament. Article 117 requires President's nod for introducing tax bills, money bills, in Lok Sabha. Article 265 flatly states no tax can be levied without legal authority. Article 109 gives Rajya Sabha only 14 days for money bills.
More provisions.
Yes. Article 112 also requires the budget to clearly separate expenditure charged on the consolidated fund, which isn't voted on, from other expenditure, which is voted on, and also to distinguish between spending on revenue account versus other accounts. Article 113 limits the Lok Sabha. It can approve, refuse, or reduce demands, but it cannot increase them. Article 114 prevents amendments to the appropriation bill that would change the amount of voted grants or charged expenditure. It's a tight framework.
You mentioned charged expenditure isn't voted on. What kind of things fall into that category? The source lists them.
These are essentially fixed, constitutionally protected expenses. It includes the president's salary, allowances, and office costs. The salaries and allowances of the Lok Sabha Speaker, Deputy Speaker, and the Rajya Sabha Chairman, Deputy Chairman. Salaries, allowances, and pensions for Supreme Court judges. Pensions for High Court judges. The salary, allowances, and pension for the Comptroller and Auditor General, Gauge. Same for the chairman and members of the Union Public Service Commission, UPSC.
What else?
The administrative expenses of the Supreme Court, the CAG's office, and the UPSC. All the debt charges the government of India is liable for, like interest payments. Any money needed to satisfy court judgments or awards against the government, and any other spending that Parliament itself declares by law to be charged. Listing these shows which costs are considered non-negotiable aspects of running the state machinery.
Okay, so how does the budget actually get passed? The source outlines 6 stages.
Stage 1. Presentation. The finance minister presents the budget, usually with a detailed speech, in the Lok Sabha. It's then laid before the Rajya Sabha. Traditionally, this was the last working day of February, but since 2017, it's been moved earlier to February 1st. No discussion happens on the presentation day itself.
What's stage 2? General discussion.
This happens a few days later, in both houses, usually lasting 3 or 4 days. They discuss the budget as a whole, the broad principles, the government's fiscal policy direction, but importantly, no specific demands are voted on yet, and no cut motions can be moved at this stage. The finance minister gives a reply at the end.
Stage 3, scrutiny by departmental committees. This sounds important.
It is. After the general discussion, the House is typically adjourned for about 3 or 4 weeks. During this recess, the 24 departmental standing committees, each covering a group of ministries, examine the detailed demands for grants related to their ministries. They scrutinize the spending proposals, can question officials, and prepare reports with their observations and recommendations.
This committee system is relatively new.
It was properly established in 1993 and expanded in 2004. The source credits it with significantly improving Parliament's ability to exercise detailed financial oversight, which was difficult for the whole House to do before. The committee reports are then submitted back to both houses.
Stage 4, voting on demands for grants. Where does this happen?
This happens only in the Lok Sabha. Based on the committee reports, the Lok Sabha discusses and votes on the demands for grants, ministry by ministry. Once a demand is voted and approved, it becomes a grant.
So Rajya Sabha has no role in voting on spending?
None whatsoever. It can discuss the budget and the demands, but the power to grant money rests exclusively with the Lok Sabha. And the voting is only on the votable part of the expenditure. The charged expenditure is not put to vote, though it can be discussed.
This is where members can try to cut spending, cut motions.
Exactly. During the voting on demands, any Lok Sabha member can move a cut motion, proposing a reduction in the amount demanded. There are 3 types, as the source details. 1. Policy cut. Reduces the demand to 1. This signifies complete disapproval of the underlying policy. The member moving it usually advocates an alternative policy. 2. Economy cut. Reduces the demand by a specific amount, lump sum, or by cutting a specific item. This suggests the amount is excessive and economy is needed. 3. Token cut. Reduces the demand by a nominal 100. This is used to raise a specific grievance or criticism related to the ministry's functioning within the scope of government responsibility.
Do these cut motions actually get passed often?
The source notes that practically they don't. Since the government usually commands a majority, cut motions moved by the opposition are almost always defeated. However, they serve a crucial purpose. They provide specific opportunities for members to debate particular aspects of government spending and policy, forcing the government to respond.
But if one were passed,
The passage of a cut motion would be seen as a major defeat for the government, expressing a lack of confidence, and would almost certainly lead to its resignation.
how does Lok Sabha get through voting on all the demands? There must be hundreds.
They use a procedure called the guillotine. On the very last day allotted for discussing and voting on demands, the Speaker puts all remaining demands, whether they've been discussed or not, to vote collectively. It's a way to ensure the process concludes within the set time frame.
Stage 5, passing of the appropriation bill. What's this for?
After all the demands have been voted on, or guillotined, an appropriation bill is introduced in the Lok Sabha. This bill compiles all the voted grants and the charged expenditure into one piece of legislation. Its passage provides the necessary legal authority for the government to actually withdraw money from the Consolidated Fund of India to meet that approved expenditure. No money can be spent legally without this act being passed. It's essentially the legal sanction for the spending side of the budget.
What if the whole budget process isn't finished by April 1st, the start of the new financial year? Government still needs money to run.
That's where the vote on account comes in. If the appropriation bill can't be passed before April 1st, Parliament passes a vote on account beforehand. This grants the government enough money to cover its essential expenditure for a short period, typically 2 months, usually calculated as 1/6 of the total estimated expenditure for the year. It allows the government machinery to keep functioning until the full budget is enacted.
Is vote on account passed like a mini budget?
It's passed in the same manner as an appropriation bill. It might cover a longer period, say 3-4 months, in an election year, when only an interim budget is presented initially, and the full budget comes after the election.
Was avoiding this vote on account part of the reason for moving the budget presentation to February 1st?
Yes, that was a major objective. By starting earlier, the government aims to get the entire budget, including the final appropriation bill, passed by both houses and assented to by the president before March 31st. If successful, this eliminates the need for a routine vote on account, making the full budget effective from day one of the financial year, though an interim budget and vote on account would still be needed in election years.
Okay, so appropriation bill covers spending. What's stage 6?
Stage 6, passing of the finance bill. This bill deals with the government's proposals for financing the expenditure primarily, the taxation measures for the upcoming year, imposing new taxes, altering rates, continuing existing ones. It gives legal effect to the revenue side of the budget.
Is it treated like a money bill?
Yes, it generally follows the money bill procedure.
Oh.
However, unlike the appropriation bill, where amendments altering amounts are barred, amendments can be moved to the finance bill, for instance, to oppose or reduce a proposed tax.
Is there a time limit for passing the finance bill?
Yes. According to the Provisional Collection of Taxes Act, 1931, it needs to be enacted within 75 days of its introduction to maintain the legality of the tax proposals. Its passage completes the entire budget enactment cycle.
Beyond the main annual budget, Parliament sometimes needs to approve other grants.
Yes, for unforeseen or specific circumstances. The source lists several.
If the money voted in the budget for a particular service proves insufficient during the year.
If spending is needed for a new service that wasn't included in the original budget at all.
If the government accidentally spends more money than was granted for a service in a financial year, this is voted on after the year ends, and importantly, only after the Public Accounts Committee has examined the excess and approved it.
What about unpredictable needs?
For that, there's a vote of credit. This is like a blank check granted to the executive to meet an unexpected, urgent demand where the details can't be precisely stated in advance, like during a war. This power is exclusive to the Lok Sabha. There's also an exceptional grant for a specific special purpose that isn't part of the regular services for the year.
And a token grant.
This is used when funds for a new service can be found by shifting money from one approved item to another within the same grant appropriation, so no net extra expenditure is involved. A demand for a nominal sum, like 100, is voted just to get Parliament's approval for the new service.
Do these extra grants follow the same procedure?
Yes, supplementary, additional, excess, exceptional grants, and votes of credit are all subject to the same procedure as the main budget demands, including the need for a subsequent appropriation act to authorize withdrawal from the consolidated fund.
The source also clarifies the different funds the government manages. 3 main ones.
Yes. First and foremost is the Consolidated Fund of India, Article 266. All government revenues, taxes, duties, loans raised, and loan repayments received go into this fund. All legally authorized government expenditure is paid out of this fund. The absolute rule is no money can be withdrawn from it except under an appropriation made by parliamentary law.
Second is the Public Account of India.
Also under Article 266. This holds all other public money received by the government that doesn't go into the consolidated fund. Think of things like Provident Fund deposits, small savings collections, judicial deposits, departmental deposits, remittances, etc. It's more like a banking operation. Money in this account generally doesn't belong to the government.
Does withdrawal from the public account need Parliament's approval?
No. Payments from the public account can be made without specific parliamentary appropriation. They are handled through normal executive action based on banking procedures.
And the third fund.
The Contingency Fund of India, Article 267. This is a special fund set up by an Act of Parliament, the Contingency Fund of India Act 1950. It's like an imprest, a fixed amount placed at the disposal of the president.
For what purpose?
To allow the executive to meet unforeseen expenditure urgently before Parliament can authorize it through a supplementary grant. It's for emergencies. The fund is held by the Finance Secretary on behalf of the president.
And withdrawals from here? Parliamentary law or executive action?
Like the public account, withdrawals from the contingency fund are made through executive action to ensure a quick response to unforeseen needs. However, any amount drawn must later be approved by Parliament through a supplementary grant, and the amount withdrawn is then recouped to the contingency fund from the consolidated fund.
So consolidated fund needs prior parliamentary law for withdrawal. Public account and contingency fund operate via executive action, though contingency fund needs post facto parliamentary approval. That's a key distinction.
Absolutely. It defines the core area of Parliament's direct financial control versus limited executive flexibility.
Okay, we've covered structures, people, procedures for sessions, lawmaking, and finance in great detail. Let's step back and look at the overall powers and functions of Parliament. The source calls it multifunctional.
Yes, its central position comes from the wide range and significance of its powers. The source groups them into several categories: legislative, executive, financial, constituent, judicial, electoral, and a few others.
Legislative power is the obvious one, lawmaking.
Primary function. Parliament has exclusive power to make laws on the 98 subjects in the Union list, plus any residuary subjects not mentioned in any list. On the 52 subjects in the concurrent list, it shares power with states, but Parliament's law overrides a conflicting state law.
Can it ever make laws on the state list subjects normally reserved for states?
Yes, but only in 5 specific exceptional circumstances mentioned in the Constitution. 1. If Rajya Sabha passes a resolution, Art. 249 special majority, saying it's necessary in national interest. 2. During a national emergency. 3. If 2 or more state legislatures request Parliament to do so for them. 4. To implement international treaties or agreements. 5. When a state is under president's rule. These are specific, usually temporary overrides of the normal federal division.
Next, executive powers. Controlling the government.
Crucial in a parliamentary system. The Council of Ministers is collectively responsible to the Lok Sabha. Parliament, particularly Lok Sabha, holds the government accountable. The most potent power is Lok Sabha's ability to remove the government by passing a no-confidence motion.
Are there other ways Lok Sabha shows lack of confidence or dissatisfaction?
Yes, the source lists several actions that have similar political implications. Defeating the motion of thanks, rejecting a money bill or another crucial government bill, passing a censure motion or an adjournment motion, defeating the government on any vital policy issue, or even passing a cut motion during the budget. These are all signals from the legislature to the executive.
The source quotes someone on this.
Yes. N. Mulya, who described Parliament's first function as being to select, support, sustain, and if necessary, expel the government based on whether it retains the House's confidence. A good summary.
Financial powers, we've covered the budget process, but the overall control.
Parliament holds the purse strings. No tax can be levied, no expenditure incurred from public funds, no money withdrawn from the consolidated fund without Parliament's specific approval.
How is this control exercised?
Through budgetary control, the whole process of enacting the budget before spending happens, and post-budgetary control, scrutiny after money is spent, mainly through the three financial committees, public accounts, estimates, and public undertakings.
The source mentioned the rule of lapse. What's that again?
It means that the money granted by Parliament for a financial year must be spent within that year. Any unspent balance doesn't carry over. It lapses and returns to the consolidated fund. This ensures the executive has to come back to Parliament each year for fresh approval. Principle of annuity.
But it has a downside.
Yes. The source notes it can lead to that inefficient March rush departments hurrying to spend remaining funds before the financial year ends on March 31st just to avoid losing them. An interesting operational consequence.
Parliament also has constituent power to change the Constitution.
Yes, a very significant power. Parliament can amend the Constitution by adding, varying, or repealing provisions. The process for initiating amendments lies exclusively with Parliament, except for state legislatures requesting changes to their own council structure.
And the amendment methods vary.
Yes, based on the provision being changed. Some minor things by simple majority, like ordinary laws, most by special majority, absolute majority plus 2/3 present and voting in each house, and core federal features by special majority plus ratification by half the state legislatures.
Is this amendment power unlimited?
No, this is vital. The Supreme Court, in the Kesavananda Paradi case, 1973, established the doctrine of the basic structure. Parliament can amend the Constitution, but it cannot alter or destroy its fundamental features, its basic structure. That's a major limitation imposed by the judiciary.
Does Parliament have judicial powers too?
Certain quasi-judicial powers, yes. It can impeach the president for violating the Constitution. It can participate in the removal of the vice president. It recommends the removal of judges, Supreme Court, High Court, the Chief Election Commissioner, CAG, etc., to the president after following a set procedure. And it can punish its own members or even outsiders for breach of privilege or contempt of the House.
What about electoral powers?
It plays a key role. Parliament's elected members participate, along with state MLAs, in electing the president. Both houses together elect the vice president. Lok Sabha elects its speaker and deputy speaker. Rajya Sabha elects its deputy chairman.
Does it make laws about elections?
Yes, Parliament is authorized to make laws regulating elections to the president, vice president offices, and to Parliament itself in state legislatures. Key examples are the Presidential and Vice Presidential Elections Act 1952 and the Representation of the People Acts of 1950 and 1951, which govern the whole electoral process.
Finally, the source lists some other powers. A mixed bag.
Yes, covering various functions. Parliament acts as the highest forum for deliberation, discussing major national and international issues. It has the power to approve the proclamation of all three types of emergencies: national, state president's rule, financial. It can create or abolish legislative councils in states if the state assembly requests it. It has the power to alter state boundaries, areas, or names. It can regulate the organization and jurisdiction of the Supreme Court and High Courts, and even establish a common High Court for multiple states. It shows the breadth of its constitutional mandate.
That is an incredibly wide range of powers and functions, cementing its central role. However, the source then throws some cold water on this, discussing the ineffectiveness of parliamentary control in practice.
Yes, it presents a counterpoint. Despite all these formal powers, the actual day-to-day control Parliament exerts over the executive might be more limited, more theoretical than real. The source lists several reasons why this might be the case.
What are some of those limiting factors?
One is simply the complexity and scale of modern government. MPs often lack the specialized knowledge or sheer time needed to effectively scrutinize detailed administrative actions or highly technical budget proposals. They are often generalists facing specialists.
Parliament's own nature plays a part.
Its large size and the diverse interests of its members can make focused, sustained scrutiny difficult. Also, the initiative for most legislation and major policies lies with the executive, the government, giving them agenda control.
What about delegated legislation and the guillotine?
Yes, the government's power often comes through delegated legislation where Parliament passes a broad law, and the details are filled in by rules made by the executive bureaucracy, reducing direct parliamentary input on specifics. And the use of the guillotine during budget debates means large chunks of spending are often approved without any discussion at all.
Do parliamentary committees fully compensate for this?
The source suggests maybe not entirely. While committees do vital work, their recommendations are typically advisory, not binding on the government. And their reports might not even be debated by the full House. Their influence can be limited.
Any of the factors mentioned?
The frequent use of ordinances, temporary laws made by the president when Parliament isn't in session, can bypass immediate parliamentary scrutiny. Parliamentary control is often seen as more sporadic, focused on major political issues rather than continuous administrative oversight. And the source also points to factors like the relative strength of the opposition and overall parliamentary behavior and adherence to ethical norms as influencing the effectiveness of control.
These are important qualifications to the picture of an all-powerful parliament. It suggests a gap between formal powers and practical reality. This actually leads nicely into comparing the Indian parliament with the British concept of parliamentary sovereignty.
Right. That doctrine of sovereignty of parliament is really a defining characteristic of the UK's constitutional system. Sovereignty meaning supreme, ultimate legal power within the state.
And the British parliament embodies this.
According to traditional constitutional law, yes. Thinkers like A.V. Dicey describe the British Parliament as having unlimited legal authority, no legal restrictions on what it can legislate on.
What does that mean in practice for the UK?
Several things, based on Dicey's analysis in the source. 1. Parliament can legally make, change, or repeal any law on any subject. The famous quote attributed to Delum is that Parliament can do everything except make a woman a man and a man a woman, hyperbole, but illustrates the point of unlimited scope. 2, it can make constitutional laws using the exact same procedure as ordinary laws. There's no legal distinction between its constituent power and its legislative power. Crucially, acts passed by the UK Parliament cannot be declared invalid or unconstitutional by the judiciary. There's no system of judicial review of primary legislation in the same way as in India or the US.
So, by contrast, the Indian parliament is definitively not sovereign in this sense.
Absolutely not. The source is very clear. The Indian Parliament's authority is defined, limited, and restrained by the Constitution itself. Several key features prevent it from being sovereign like the British Parliament.
What are those key limiting factors again? Let's recap.
4 main ones stand out in the comparison. 1, a written constitution. India has one, the UK doesn't, in the same codified sense. The Indian Constitution is the supreme law, and Parliament is bound by it. 2, federal system. India divides power between the Union and states. Parliament's legislative scope is largely defined by the Union and concurrent lists. The UK is a unitary state where all legal power theoretically resides in the central parliament. 3, system of judicial review. India has it, the UK, for primary legislation, doesn't. Indian courts, Supreme Court, High Courts, can strike down parliamentary laws if they violate the Constitution. 4, fundamental rights. Part 3 of the Indian Constitution guarantees justiciable fundamental rights that limit Parliament's lawmaking power. Article 13 explicitly forbids laws violating these rights. The UK lacks a similar codified, constitutionally entrenched Bill of Rights that courts can use to invalidate acts of Parliament, though human rights laws have other effects.
So while India borrowed the parliamentary form, it deliberately embedded these major constraints, making its parliament powerful but not legally supreme or sovereign.
Exactly. The source concludes this point by saying that in terms of being limited by a constitution, federalism, judicial review, and rights, the Indian Parliament is actually more akin to the American legislature, Congress, than the British Parliament. Both operate within defined constitutional boundaries.
This has been a really comprehensive journey through the Indian Parliament. We've gone from the basic structure president, Rajya Sabha, Lok Sabha, and how members are chosen and disqualified.
To the roles of the key presiding officers like the speaker and chairman, their powers, their election, removal.
Then into the mechanics of sessions, adjournments, prorogation, dissolution, and the crucial rules about lapsing business.
Different types of voting, the various majorities needed, the languages used.
And the whole array of procedural devices members use: question hour, 0 hour, motions of different kinds, resolutions.
Followed by the detailed legislative process for bills, especially ordinary bills, money bills, and the mechanism of joint sittings.
Then the deep dive into financial procedures, the budget stages, charged expenditure, the different funds.
Leading to the broad overview of Parliament's extensive powers: legislative, executive, financial, constituent, judicial, electoral.
balanced by the discussion on the practical limitations and effectiveness of parliamentary control.
And finally, contrasting the Indian system with British parliamentary sovereignty, highlighting the constitutional constraints like federalism, judicial review, and fundamental rights.
It really paints a picture of a complex, powerful, yet constitutionally bound institution, blending inherited traditions with unique Indian adaptations. We've seen the checks and balances, the evolution through amendments, the procedural innovations.
And the ongoing tension between the formal powers laid out and the practical realities of exercising effective oversight in a complex, modern state.
So here's a final thought for you, our listeners, to ponder. We've dissected the intricate machinery of the Indian Parliament, the rules, the procedures, the majorities, the debates, the powers, the limitations. Considering all these nuts and bolts, how do you think the detailed functioning of this institution, day in and day out, shapes the actual laws and policies that affect your daily life? Does understanding these mechanics, how a bill becomes law, how the budget is passed, how the government is held accountable or not, change how you view or engage with India's democracy?
It's certainly a system designed with intricate checks and balances, operating within a specific, carefully crafted constitutional framework. Understanding it is key.
Absolutely. Knowing the rules of the game is fundamental. Thanks for joining us for this deep dive into the Parliament of India.
My pleasure. It was fascinating to cover.